So then, welcome everybody. My name is Jeff Gedman with American Purpose, an online magazine, AmericanPurpose.com, and an ideas network, a policy forum. Glad you could join the Zoom discussion with us today. Luke Phillips, in advance, thank you and Braver Angels for partnership today and on other days too. We value you and what you do greatly. I have been excited about this program since Bob Asahina and Ed Warren spoke to me about it. Bob is known to many of you as an important editor, writer, book author, public intellectual. To me, near and dear because he is now a member of our editorial board at American Purpose, and that's very important. I feel you all often, and today in particular, like a kid in a candy store, because with so much posturing out there on issues like the Supreme Court, it's actually so valuable and interesting to me, and I trust you agree, to learn actually how the Supreme Court functions and what things look like in practice. So Bob and Ed, you're doing a real service for us today. We're looking forward. That's my bit in welcoming and scene setting. Luke will give a tech talk, give a proper introduction of Bob Asahina and Ed Warren, and Luke is kind enough to facilitate the Q&A too that will take place. But welcome everybody, and Luke, over to you.
Thank you, Jeff, and it's an honor to work with American Purpose on these events as always. So everybody, welcome to America's Public Forum. This is going to be an interesting conversation today. I'm excited to get into it. So real quick, tech talk. First off, please keep yourselves on mute over the course of the conversation until we get to the Q&A. Second off, once we get to the Q&A, you will be asked to raise your Zoom hands. If you know how to raise your Zoom hands, please go ahead and do that now so that we know how you know how to do it. All right, there we go. Cool. So yes, once we get about halfway through, you'll be asked to raise your Zoom hands, and then you'll be able to unmute and ask your questions to the speakers. And then lastly, we will be keeping the Q&A box open, or the chat box open. So you're welcome at all times over the course of this to share your thoughts and questions in there as well. So without further ado, the Supreme Court of the United States obviously is one of the three branches of government, and being as central to the American political system as it is, it's often drawn into a lot of major partisan fights, right? In Braver Angels, we've looked at a lot of different issues in polarization over the last 4 years, but I distinctly recall that during the confirmation hearing of Justice Kavanaugh, there was a huge political and media firestorm that showcased a lot of questions about the role of the Supreme Court, right? And same thing with things surrounding other appointments of Supreme Court justices. And then additionally, whenever there's been a major court case being decided, there's been oftentimes weeks or even months of major public debate on these things. So what happens in the Supreme Court matters. And I think a lot of us are often assuming that it is just as divided as the rest of American society and just as divided as the rest of American government. Our guests today have thought a lot in depth on this, and one of them in particular has argued in front of the court many, many times and has a different perspective on it. And the notion that just as in some of the glorious days of the Supreme Court in past centuries, there is actually a surprising amount of comedy and unity and consensus building among the justices, which to my mind is a very good thing to hear, and a very good thing as well, just for the stability of American political institutions. And maybe there are even things that the rest of us can learn from how the Supreme Court does its internal business the majority of the time, as to how to think about the great issues of our public life. So I'm excited. Braver Angels is honored to partner with American Purpose to bring you this conversation. And I'd like to introduce our two speakers. So first off is the MC, Bob Asahina. Bob is a former editor and publisher and the author of a book called Just Americans. We will put the link to that in the chat later. Bob, thank you for joining us today. And our speaker is Edward W. Warren. Ed is a counsel to Kirkland and Ellis LLP and a prominent appellate lawyer who has argued many cases in front of the United States Supreme Court, #1, and also various other United States District Courts, #2. So we have two guests here, an MC and a speaker who have been thinking about issues of American jurisprudence experientially for quite some time, and we're honored to be with them to share their insights. So Bob, Ed, let me hand it off to you.
Okay, thanks very much. Ed, great to see you in Montana. It occurs to me that every year around this time, we talk about the decisions that the court has handed down, and every year you express the same frustration with how people think about the court and what it does. And I know that two of your pet peeves are that people perceive the court as some kind of a super legislative body that should somehow reflect popular opinion. And the second is that the court is divided hopelessly on partisan grounds, on red-blue grounds. And in talking with you over the years, I've certainly come to see the court in a different way, but I agree with you that most people don't understand what the court does, how it does it, and why it does it. And you had some pretty startling statistics that you rattled off to me a couple of days ago, and I thought maybe you'd begin by talking about those statistics.
Yeah, let me begin by saying that I think the public at large does not appreciate the fact that the court's jurisdiction is entirely discretionary. The court can take cases at its election, and surprisingly, the docket of the Supreme Court has dramatically declined over the course of the last few decades. In the 1980s, the court was deciding 150 cases. By the 90s, it was 120. By the 2000s, it was 85. And this term, the court will have rendered decisions in only 58 cases. So there's been a marked decline in the number of cases. The court has now decided 53 of the 58 cases that are on the docket for this term. And it's interesting to appreciate how frequently the decisions are unanimous or nearly unanimous, and how frequently persons that you would expect to be vastly different in their perspective are actually voting together a large number of times. Give you an example. Chief Justice Roberts and Elena Kagan, two very fine justices, have agreed in 80% of the cases this term. Likewise, Justice Breyer has agreed with Roberts and with Kavanaugh in 77% of the times. And in ideological opposites, like Justice Thomas and Justice Sotomayor have agreed 63% of this time, and Justice Alito and Sotomayor 58% of the time. So what we see is a large number of cases where the court is split in ways that are not expected. Today, the court decided three new cases, and two of them have remarkable splits for those who are really familiar with the court. You have an Indian tribe case, Yellen versus Confederated Tribes, where Sotomayor is joined by Roberts, Breyer, Kavanaugh, and Barrett, and there's a dissenting opinion from Gorsuch, Thomas, and Kagan. I mean, these are not people that think alike, but they reach consensus, and often that consensus is quite a bit different than would be expected. And I could go on. There's several other good examples this term, but Bob, I think that kind of gets the ball rolling.
Yeah, absolutely. I think what we should turn your attention to next, Ed, is the institutional reasons for what the court does and why it does it. And a lot of those have to do with questions like the docket that you just raised, but other issues that I think people just sort of think that the court wades into high profile cases, when in fact that's not the case.
No, it's not the case at all. Because their docket is discretionary, very frequently hot button issues simply are not taken by the court. And the court's principal job is to resolve conflicts among the circuits, so that one circuit is deciding X and another circuit is deciding not X. And so it's easy for the court to say, let's wait, let's see how this issue plays out in 2, 3, 4 circuits. And frequently they take them at several years after the issue has arisen in the first instance.
And I noticed that you pointed out that there are a couple circuits like the 9th and 6th that are frequently reversed.
Yes. The 9th Circuit is notorious because it has been for many years the kind of liberal bastion. This is California, Washington, Oregon, and so forth. And this term, the court reversed 10 of 11 decisions by the 9th Circuit, and they reversed all 6 of the decisions that were before the court from the 6th Circuit, which is Ohio and Michigan, Illinois, not Illinois, actually, Michigan, Ohio, and the Midwest. So what you see is and then I think, let me say something about the shadow docket of the court, because I think this is something that gets into the press, because what's happened recently, and this is really kind of a new thing, is because of a press of circumstances. This could be the coronavirus policies, it could be Trump executive orders or executive orders in general. The court has been forced to take on an emergency basis certain kinds of cases, but not to put them on the full docket. They just come up as emergency questions of, are we going to stay the lower court or the district court? And sometimes these produce 5-4 decisions. And so I think the press tends to focus on those, but those are not precedents of the court. There's no written opinion usually. And the whole opportunity for developing a consensus, which John Roberts has been so adept in doing, is lost in those cases that are on the shadow docket.
You mentioned Roberts, who is often referred to as an institutionalist. And I was struck particularly by the Catholic Social Services case and the city of Philadelphia, which, if you look at the opinion, is kind of an extraordinary opinion in bringing together so many disparate points of view on the court in what was a fairly narrow decision, and one that did not challenge the overriding precedent as well. And I wonder if you could talk a bit about that.
Yeah, I think that is an excellent example, and there are many by John Roberts, because what John Roberts did essentially was to say, we don't need to do what people thought, that is, overrule the Smith decision. Instead, we can interpret what's going on here in Philadelphia against that precedent, and then we still would result in a reversal. So the whole question resolved around whether or not the licensing provisions and the contractual provisions by the city of Philadelphia were neutral and general in nature. What Roberts concluded, and this was really a narrow decision, was no, they're not, because there was a mechanism against which exceptions could be granted. And consequently, it was not neutral. And consequently, the contractual provisions, which they also said this is in violation of the public accommodations law, the petitioners, and he said, no, this is not a public accommodations law. So, he ended up getting 7 votes in support of a very narrow decision. And yes, it's left for another day, the broader questions of whether or not these kinds of decisions by local governments are in violation of the freedom of religion clause or the free speech clause. And this was the second example of having avoided this issue, or these issues. As you may recall, 2 terms ago, the court also ducked in the so-called Makepeace Cake Shop case, where a baker refused to do wedding cakes for same-sex couples. And there, Justice Kennedy wrote an opinion, which again ducked the harder questions. So this happens frequently, and it happens because of the institutional commitment. And John Roberts is a superstar at this, but I think it reflects everybody on the court, respects the court as an institution and its role and limited role in society. It is not a super legislature. It is a body to decide a limited number of cases which meet the case or controversial requirements of the Constitution. And even then, the instinct has always been, and it certainly is true today, to decide narrowly and leave for another day the broader implications.
And one thing you're constantly pointing out to me is how the sort of popular focus on constitutional rights really overshadows the fact that a lot of what the court does is textual interpretation of existing statute. And the confusion that everything the court decides is a matter of establishing constitutional rights is a great misperception, I think, on the part of both the media and the public.
Yeah, I would begin by saying that the lion's share of the court's docket is statutory interpretation. And the interesting thing about statutory interpretation is the court has actually changed pretty dramatically over the last 30 years in how it approaches statutory interpretation questions. And for that, I think the leader has been Justice Scalia. Justice Scalia's jurisprudential approach has garnered, I think, really a majority of the court, almost everybody. And it vastly is in contrast to what the court was like before Justice Scalia came along. Now it is a textual court. A good example of this is a little bitty case, Van Buren versus the United States. It was decided earlier this month. And it was a 6-3 decision. And everybody, all 9 justices in this 6-3 decision, looked only at the words of the statute, and it turned on what the word as meant within the context of the statute. This is in vast contrast to the Warren Court, for example, which was always looking at the overriding purpose and was consulting legislative history and really making it up as it went along. But now the guidelines are, let's stick to the text and the structure of the statute. And that's the way most of the cases are being decided, because most of the cases really are statutory interpretation cases.
Yeah, again, just to emphasize, I think there's a lot of popular misunderstanding of what you're calling statutory interpretation and what commentators call originalism regarding the Constitution. And the fact is, as you've pointed out over and over again, a lot of this has to do with existing statutes. It doesn't have to do with reinterpreting the Constitution.
It really has nothing to do with it, actually. But originalism is a different issue, and it's interesting to see that Justice Scalia, who was such an originalist, has, on that score, not succeeded at all, or almost at all. I mean, the court has not overturned Roe versus Wade, and it is again marched in the direction of providing additional rights in unusual cases like the Obergefell case last term on gay marriage. The court has argued a lot about originalism, but it's a small part of the docket, and even Justice Scalia has gotten into some trouble on the originalism arguments because of the Heller case, which was the guns rights case several terms ago. Mm-hmm. But that's right. I think the court if you look at the docket of the court and you look at what's happened this term, you see most everything is statutory interpretation. And you see another element of the court's jurisdiction, which is a very serious requirement that there actually be a case or controversy under the Constitution.
Yeah, I was just going to turn to that next, which is really to talk about two issues that come up all the time in discussions of the court. The first is standing, and the second is precedent. And I wonder if you could elaborate on that a bit.
Yeah, well, in terms of standing, before Justice Scalia came on the court, it was observed variously and inconsistently. And then in 1992, Justice Scalia led a 5-4 decision in the Lujan case, and that set forth a very clear constitutional standing approach. There has to be actual injury. The actual injury has to be traced to the statutory or constitutional requirement, and it has to be the case that the court's decision can redress the injury, which is traced to the claimed injury by the plaintiffs. And this has knocked out a lot of cases. There was another one today, another standing case today. But you had the California versus Texas case, which is the return of Obamacare. There's a 6-3 decision there written by Breyer. And what you see, Breyer has actually been a very important justice this term. 3 of the most important cases he has written. And that is, I think, again, a reflection of the consensus building that's going on here, because he is writing narrow decisions that just don't disturb existing precedents, and that's certainly true of Obamacare. The court is just very reluctant to get back into this thicket. There was a disagreement with Roberts going upholding the statute on a 5-4 decision on the tax ground. I know it's been 10 years ago now, but they don't want to reopen these cans of worms. Decisions like the Obamacare decisions.
Right, which brings me back to the question of precedent. You mentioned how in the Philadelphia case, the court sort of punted in the same way they did regarding the Colorado Baker case by deciding something very narrowly and not upsetting precedent. And I wonder if you could talk a bit about that, because one of the great concerns of the left right now is Roe v. Wade and the prospects of overturning a firmly established precedent.
Yeah, I am a believer that they will not overturn Roe versus Wade, but there will be, and there is, and will be before the court next term, issues about what happens in the second trimester, the third trimester, various regulatory provisions imposed by state legislatures, and exactly which of those, if any, will be upheld. It remains to be seen. I think there will be some coming back of Roe versus Wade, but I don't think that. I mean, you've got Roe versus Wade, and then you have a really plenary evaluation of Roe and Casey about, now it's been almost 25 years ago. And I think it's solidly entrenched and is not going to be overturned. But there will be, I think, decisions around the periphery that will cut back the right in certain respects.
So you mentioned 2 areas where you say Scalia has triumphed. One is in textual interpretation of statute, and the second is this question of standing. You also mentioned that there was another area where the Scalia approach has not triumphed, which is in the construction of rights. And I wonder if you could talk a bit more about that.
Yeah, well, I think he has been a longstanding originalist, and I think the originalist perspective has gained traction in the court, but not to the point that I think it's likely to lead to overturning Roe and many other decisions in this area, privacy decisions. Another example would be capital punishment. Scalia was very much opposed to the notion that the Eighth Amendment, cruel and unusual punishment, would ban or at least cut way back statutory capital punishment, because obviously historically capital punishment was well established when the Constitution was written, and so why this new right? If it wasn't bad then, why is it bad? But at any rate, he's lost those battles. He's lost almost every major battle in the originalist perspective.
Mm-hmm. And again, just to keep emphasizing the point, when you're talking about textual interpretation, you're not talking about constitutional cases. You're talking about statute. And I think that's an important distinction to make. Finally, speaking of statute, I wonder if you could sort of preview an issue that is going to loom very large over the next court session, which is the Chevron decision, which is not something that I think most lay commentators know much about, and yet in some ways it's a bigger decision than practically anything that the court could be handing down. So you could talk a bit about Chevron and lay the groundwork for why it's important.
It really is, and this is a Scalia issue particularly. When Scalia went on the DC circuit, he was surrounded by Chief Justice Bazelon, Skelly Wright, McGowan, Leventhal, judges who really saw a big judicial role. And consequently, what they often did was looked at the overall purpose of a statute, created additional causes of action. They would read into the statutory language based on legislative history, very liberal interpretations of what the words meant. And Scalia really fought that. And one of the things that when he got on the court in 1984, there was a decision actually written by Justice Stevens called the Chevron decision, which basically established a rule of statutory interpretation, which says essentially, when a statute is ambiguous, when we can't say whether it means X or not X, we should be deferring to the agency's interpretation of that statute, unless the agency's interpretation is just simply unreasonable and insupportable. And the Chevron has since then become probably the most cited Supreme Court decision over the last, let's see now, it's been 40 years. Scalia has interpreted the Chevron decision in a way that Justice Stevens never intended, I think, which is essentially that Chevron reflects what is an implicit blanket delegation to Congress to interpret statutes, which then have determinative effect or nearly determinative effect on the courts of appeals. Now, this affects the docket for sure, because if Chevron controls, then what happens is you have much less circuit conflicts because everybody's following what the agency does. The court's docket gets cut back, and Scalia saw that as a great way to reduce the docket, to reduce the court's role, and so forth. But it is increasingly on the left and on the right a matter of grave concern. And in the next term, in the next 2 terms and 3 terms, I think we'll see more and more cutting back on this. Thomas is against it. Gorsuch has written about it. Breyer is skeptical in certain respects. And this is going to be an issue that you would think, oh, gee, this is a hyper-technical issue. No, it's dispositive in many, many cases. And I guess I spent more of my time arguing about Chevron and standing than just about anything else. And so this is a very important issue. And I think what we're going to see is that it is going to be cut back, because it's always been true that Chevron is directly contrary to the notion of Madison versus Marbury, which is that it's the court's job to interpret statutes. And that is exactly what the Administrative Procedure Act, which figures so prominently in all of this, says also. So I think Chevron is one of these issues that certainly the press has a hard time seeing its significance, but if you're arguing cases, you know it's of central importance.
And this actually is a constitutional case. I mean, if it involves Marbury versus Madison and the Administrative Procedures Act, this has fairly large implications for governance that much narrower cases of individual rights do not have.
Right, that's all true, but I think again the reluctance of the court to override precedent applies here just as much. So, for example, the court has already cut back on what's called the Seminole Rock set of cases, which it means that you should apply the same Chevron standards to the agency's interpretation of its regulations and its non-regulatory actions. So I think what we'll see is a cutting back, but Chevron, I don't think Chevron is going to be overruled, just as I don't think Roe versus Wade is going to be overruled, or many other decisions which have longstanding precedential significance in the court. Very clever lawyers can work around things, as John Roberts has repeatedly shown us.
And at the same time, the institutional imperatives can find a way to work around what are perceived, and I believe often incorrectly, as simple partisan issues. So I'm impressed with your emphasis on the institutional role of the court. And I wonder if you could add a little bit more about Roberts's perhaps most enduring legacy in this regard.
Yeah, I think John Roberts has always seen himself as an heir to Chief Justice Marshall, the first Chief Justice, and I think he cares most about the role of the court as an institution, and I think that's the abiding consideration in what he's trying to accomplish. But I think he's really good at consensus building too. And the press after Barrett's confirmation said, "Oh, we have now a 6-3 court." Well, that's not true. I mean, it's already clear that the press is saying, well, no, what we really have now is a 3-3-3 court, where we have Kavanaugh and Barrett and Roberts in the middle, and the three conservatives, Thomas, Alito, and Gorsuch at the other extreme, and so on. I think that's not true. I think I have long predicted that Kavanaugh will have an institutional perspective very much like John Roberts, and that they would likely vote together. Barrett, I think it's way too early to predict where she's going to come out on any case or most cases. I mean, she's a junior justice. She's trying to be respected by the members of the court, just as any junior who comes into a body of senior superstars, and she's needing to prove herself. And so she joins in with John Roberts in these early stages. Whether she will or won't, I don't know. And Gorsuch is a complete wild card, I think. I mean, to think that he's going to be always aligned with Alito and Thomas strikes me as just insanity. I mean, he was the one, after all, who wrote the Bostock case, where the court interpreted the employment protections of the civil rights laws to protect same-sex couples and transgender. I mean, he led a decision 6-3 with Roberts on board with him, and then with the then 4 liberals to do that. And I think Gorsuch is very hard to predict. So I think all the talk that you see in the press about, oh, it's solidifying into 3-3-3 instead of 6-3, I would say, let's wait and see how it all plays out in 2, 3, 4, 5 terms.
And again, the immediate reaction to the Philadelphia case struck me as being a lot of head scratching and bafflement. I mean, on the one hand, the Smith president, you have the Wall Street Journal complaining that it didn't go far enough in, overturning that. And on the other hand, you have the Times complaining that this is, establishing religion. So the misperception of that decision and what was going on by Roberts, skillful narrowing of the scope of it and building a consensus. Again, I don't think people understand what the court was actually doing in that decision. They just saw it partisan lens.
I mean, again, what the court was doing, and the examples of what Roberts has done in analogous or situations, it's really remarkable. I mean, he is a consensus builder, and if he can get a narrow decision, this is, after all, if you step back, the most famous book about the role of the court probably is still Alexander Bickle's The Least Dangerous Branch. And it reflects the notion that the decisions in society should be made by Congress and implemented by the president, and the role of the court should be very modest, and it should not be usurping the role of either the legislative or executive branches. And Roberts, I think, is a great believer in that. So institutionally, he is in favor of the court playing a diminished and lower profile role in societal decisions. And I think most of the members of the court feel that way. Certainly, Justice Alito probably would be the best counterexample. But I think Breyer sees eye to eye, as far as I can tell, and Kagan too, with Roberts on these kinds of issues.
Mm-hmm. Well, maybe one closing comment you could make is about Breyer, who has, as you pointed out, sort of stepped up in handing down or writing many of these decisions, but at the same time, is under great political pressure to retire. And I wonder if you could comment on that from an institutional perspective.
Of course, it's anybody's guess what he actually does, but I would say he believes in the role of the court. And he believes that the court as an institution should continue to play a relatively modest role. That I think he does. Mm-hmm. And I think he will be reluctant to give in to public pressures for him to step down, because it tends to underscore the misapprehension that the court is a political institution, and that it's simply vote counting on the left and the right and very predictable. And it's just like Mitch McConnell versus Schumer or something like that. Right. It's not like that. And I think Breyer respects the role of the court. I'd be surprised if he does it, but he might. I mean, it is true that if after the 22 election, Republicans regain the Senate, it would be hard to confirm a replacement. So he may, but I think his health is okay. He's sharp as a tack. He's written, what I say, 3 of the top 8 decisions this term. I think he enjoys his role. He's respected in it, and I would be surprised if he does it. But there are countervailing pressures for sure.
Okay, maybe this is a good time to field some questions, Luke.
Sure thing. I'll go ahead and start off just because I have something burning in the back of my mind here too. But Ed, one of the big questions about the quote unquote politicization of the court back in the 2020 election was the question of court packing, right? Like theoretically, could a president of the United States go and appoint up to 12 or up to 15 or maybe more justices to stack the court in one ideological direction or the other? And so I just was wondering, number one, what how those concerns look like to somebody like yourself who actually works with the Supreme Court, number one. And then number two, given what you're saying about the surprising amount of consensus building and proceduralism that makes the court less about vote counting and more about deliberation, would court packing actually significantly change the nature of the court and the decisions it's making if it were to happen in some future time frame?
Well, first of all, constitutionally, 9 justices is not required by the court. I mean, it is possible for Congress to expand the court. Now, as we all know, the first time that was thought about and tried in the New Deal era by President Roosevelt, it was a political disaster for Roosevelt. So I think that's a warning in and of itself. Secondly, even Justice Ginsburg and Justice Breyer have, in mild ways, sort of parted company with the idea that we should expand the court. I think it would be a terrible, terrible idea, and would thrust the court into a very different role, almost necessarily. And I think it would be what we want to have in the court is continuity. And if what you have is, okay, we expanded to 12, and you get 3 new Democratic appointees, so that now you've got a so-called 6-6 court. Okay, then the Republicans win the election in 2022, and they say, yeah, let's just do one better. Let's just add up 3 more justices, and we'll appoint them. And you know, this is a warfare that is going to just be a disaster for the court and for the country, I think. So I hope and pray that it doesn't happen. And I think on that, there's probably 9 justices on the Supreme Court that are praying along with me.
So everyone, we are now in the Q&A segment of this. So if anyone has questions about what's been discussed and other things related to the workings of the Supreme Court, now is the time to raise your hands and ask them. Ed, I have another question, I guess, that hits this historically too. So you talked some about possible tweaks around the edges of Roe v. Wade. And it reminds me that there's been various cases at key points in national history, like the Schechter Poultry versus the United States decision,
right,
or obviously the Dred Scott decision a century before that, that have been very much on directly one side versus the other side polarizing questions, and have taken one of the options off the table, right? Do you think that that's built into the nature of the Supreme Court, and do you think that the consensus building operations inside the court make those decisions better than they would be if they were decided in the legislature? Or what's your thinking on that?
Yeah, well, let me give you an example of a case that was decided last week, and this is the takings case. It's called a Cedar Point Nursery. In a 5-4 decision, what the court held was that a mandatory access, this is talking about farm workers, and none of the farm workers lived on the property where the farming was taking place, but the state of California ruled that they would have access to do union organizing on the property of the owners of the cases of the nursery. And in a 5-4 decision, what Roberts held that was a takings. And there's been a groundswell on the right for many years to take much more seriously the takings clause of the Constitution. And indeed, one of the people that I know very well, who was a professor at the University of Chicago, Richard Epstein, wrote a big book on takings. And the right has always wanted to see this expand. Now, I read the decision, and it's really narrow. And the idea that this is going to open up a swing to the right on economic cases, takings cases, I think is just, it's written so narrowly that I think that's never going to happen. So in every direction, when you get gun rights is another example where you say, oh, individual right to bear arms is protected by the Constitution. Well, but the court makes it clear that regulations of all kinds are permissible, and that issue ought to be, as every other issue, decided by the Congress and by executive branch enforcement, not by the court. So I think the whole idea, I mean, even Roe is a good example where I think even Justice Ginsburg sort of said, hey, maybe it would have been better if we'd done it a little bit differently, if we would have made it not so sweeping, because then, there's so much to be said for incremental, step-by-step jurisprudence. And that's what I think we see on the court now. And I think we'll see it in the future.
A quick reminder to our audience that we're in Q&A. So if you'd like to ask questions of our speakers, now is a good time. Ed, I have another thing too that I'm and maybe this is a shorter question, but what would you say are the chief virtues that Supreme Court justices, and also maybe all judges as well, but Supreme Court justices especially, have that make them distinct from legislators and executives in the American system of government?
Well, I think historically, if you look at Oliver Wendell Holmes or Learned Hand, some of the really most famous judges, they have in common the sense that the law should develop gradually. That is, after all, the way common law developed. And so we are in a different world today. Common law is less significant. Statutory law is much more significant. But still, the same perspective of gradualism, of you're going to make less mistakes if you make narrower decisions, and if you let the law gradually evolve, whether in terms of statutory interpretation or the common law. And so I think those instincts, people that we end up respecting as real leaders, John Marshall, Learned Hand, who's a famous appellate court judge, and Oliver Wendell Holmes, and those with the passage of time, the perspective which they brought to the law is, I think, confirmed.
Thank you for that. I need to look into Judge Learned Hand because I keep seeing him referenced in histories. So I will add that to my reading list. Let's go to a question real quick from Cynthia O'Brien. Cynthia?
Hi, thank you, Luke, and thank you all. This is interesting. I'm calling you from Portland, Oregon. So I'm interested in the pressures there might be on the justices. Legislators have a lot of pressure on them from their constituents and their party, but I like to think that the justices are free to make the most wise decision for the good of the country. So what pressures are there on the justices that might sway them from the wisest decisions?
Well, let me speak to the so-called shadow docket that I mentioned earlier. What that consists of, usually the Supreme Court has stayed away from making short-term decisions without full briefing, without oral argument. But circumstances in the last few years have caused them to have to intervene at an interlocutory stage. Examples are, for example, the freedom of religion questions that were presented by the virus restrictions. And the court handed down a couple, not decisions, but orders, which says, yes, you can constrain religious gatherings, or no, you cannot, or, and I think that's been unfortunate. And secondly, we're in an era of executive orders. And the court has intervened on a number of occasions. This would be immigration questions, and executive orders in general, and have decided quickly things that have to be decided quickly. And I think that's unfortunate. And the reason that they've had to intervene is because district court judges have done something which is really kind of unprecedented, and they have issued nationwide injunctions, even though there are only one district court sitting in the District of Oregon, for example, and enjoining a Trump executive order which applies nationwide. The court is going to have to deal with this question of nationwide injunctions, and several of the justices have already dissented in cases where the issue might have been presented. Here again, my feeling is John Roberts is very much aware of the fact that this is a troublesome problem for the court, because it is deciding some important issues without full briefing, without oral argument, and without his magical touch in building consensus. So I think once he feels he's in a position where they can address this issue and come up with a consensus, the court's going to take a case that involves this issue. I don't know if that's helpful, but there are realities out there that cause the court to do some things which I think they would rather not do.
Let's go to a question from Suzanne Damberg. Suzanne?
Hi, thank you so much. I have only recently become more deeply interested in the functioning of the Supreme Court because I've just finished taking an arbitration class. And the area that I find particularly interesting and actually upsetting is their decisions over, there are a number of cases over the last decades where they've continually found for businesses, and the area of consumer and employee in contracts where there's mandatory, not only mandatory arbitration, but also class action waivers.
Right.
I'm curious about that. I'm curious why the court consistently, I'm wondering, from the FAA, how they've extrapolated that, why, and then is this something that really needs to go to Congress? I'm just curious what your thoughts are on this.
I think you're right about this. They have interpreted the Arbitration Act broadly, and have done so, I think, because they genuinely believe that private decision making is superior to expanding the roles of the court. So the same kind of considerations which have led them to try to keep the docket narrow and to keep cases out of court based on standing and ripeness and other jurisprudential doctrines hold here too. But there's no doubt that this is an issue for Congress. In other words, Congress can remediate and change the rules that the court has interpreted based upon, I think, a fairly broad interpretation of statute. I think you're right about that. And so there have been some surprising issues. And, I think the waiver of class actions is a good example of, you could have argued that either way. But I think they see this as a job for Congress and not for themselves.
So do you think that they will continue in this? It's just because there's rights of, I know that, harassment and sexual abuse and, other, I don't know if you call them statutory rights, but those are getting into the mix. And it just feels very problematic. And Congress is not stepping up. They've tried, I think, since the late 1990s to amend the FFA, and they're not getting their act together. There's always a lot on their plates, but also, of course, it's all politically rife. So I feel like it's just a brewing storm that is not being handled. So I was curious if the Supreme Court could or should be doing more.
Well, they've got a body of precedent now on how to interpret the statute and what rights are created and what rights are not created. And I think instinctually they think arbitration is a good thing. It reduces the burdens on the federal courts. It allows for compromise and consensus. But you can obviously argue that we need more of the court rather than less, and that some ostensible rights that people thought they had have been negated by the interpretations that have been handed down by the court. But I think they see this as generally Congress's problem to deal with, and they'll go either way based upon what Congress does.
Thank
We
you.
are just about out of time, so I would like to real quick thank Bob and Ed for this fascinating and insightful conversation, but I would also like to hand things over to Jeff Gedman to make some formal thank yous and announcements as well.
So Luke, thank you. And Suzanne, I think you wanted to go on. It would have been profitable, but there we are. So it is mine to say thank you first to all of you for valuable time. I often, as I say, feel like the pilot or purser on a plane where it said you all have a choice of airlines. We know you have a choice of Zoom discussions. There's a lot out there and good opportunities, but we're very grateful that you made time for us this discussion today. If I may plug quickly our side of things, American Purpose, please listen to our podcast. Please join our Zoom discussions. Please read us. If in 10 seconds I could turn to our managing editor, Michelle High. Usually on Friday, we like to publish one or two of our younger writers, often culture. Michelle, would you do the honors of telling us what we're posting today?
Yes, sorry. I've got Howard Schneider reviewing Mercury Rising, John Glenn, John Kennedy, and the New Battleground of the Cold War. And we've got Matt Hansen, a regular writer for us, reviewing a book about movie directors by David Thompson. I will post into chat one podcast since you mentioned. We have a terrific podcast that Richard Aldous did with Stephen Walker on Yuri Gagarin in flight, and it is a fabulous listen.
Good. Michelle, thank you for that. To Luke, penultimate, but very important. We love Braver Angels. We love working with you, Luke. You all are energy and inspiration and aspiration. And the final word, and thanks from my side, Bob and Ed, what a splendid conversation. When Bob Asahina calls me and says, I have an idea, the first thing I do is say yes. And the second thing I do is listen and take notes. This was a great idea. And Ed, you did us a real service to have you with your knowledge and your experience to walk us through this and educate us a little bit. Very, very valuable. So Ed, thanks very much. And Bob, really well done. Thank you.
Thank you.
Thank you.
Thanks, everybody. Good day, good weekend.